that in the spring successfully, thankfully. So I think I don't think you'll see as much media, especially from me, with my circumstances and my personal life with regards for this election. But the grassroots, door-to-door, what we did in the spring, we will continue to do that.
What do you think you will spend for the general?
Less than $20,000.
And what about the job itself? In a matter of months, you could be part of the Court of Common Pleas. Has that changed the way you're preparing at this point?
I think I've been preparing for this job my entire career. I've spent my entire career in the courtroom. Continue to do that. I was in court this morning. I continue to obviously practice law the way I've practiced for the last 22 years. My on-the-job training, as they say, is extensive. I'm in a courtroom basically every day. What's happened to me in my personal life, I think, has prepared me, I think, also. It's a very humbling experience to go through what my family and I are going through right now. Being out of your home, being displaced, and friends and family coming to your aid. My friends and family came to my aid in the election, and they've came to my aid in the last 2 weeks, which has been the toughest, probably 2 weeks of my life. And it's humbled me. And I'm a humble person, I think, to begin with, but the fact that the outpouring of support that I've gotten personally and professionally in the last 2 weeks, you look at your community and you say, you know, I'm a member of a really good community. And I think that's going to help me as I hopefully take the bench, looking at each individual case in front of me, how this person ended up here. And what the circumstances led to them being here. I've been a prosecutor my entire career, and obviously I look at things through a prosecutor's eye. But the last 2 weeks and what happened to us really makes me look at a whole individual person and what that person can do to help, and what I can do to help that person from the bench if help is necessary. If punishment is necessary, I'm more than can handle that. The question becomes, you know, can I help someone if they need help, treatment or some kind? And the last 2 weeks I needed help, and I got help, and I really, I'm very grateful to the people that came to my aid, and I think that could make me a better judge, the fact that I'm going through what I've gone through the last 2 weeks.
Okay. If elected, you won't be the only person in the courthouse with a new job. There's also the Luzerne County Council members,
Correct.
11 of them. We got a couple questions from a reader regarding how the judiciary might interact with the county council. The reader asks, if elected, would you be willing to work with the new county manager and county council to reduce the court's costs? Specifically, the reader wants to know, would you be willing to share tip staffs and clerks with other judges, or do you think that's even practical?
Well, for the last 22 years, I've ran a law practice, which I consider a small business. You know, I've had employees, I have employees, I have 10 employees. I will take that mindset to the bench if I'm lucky enough to be elected. You have to run the courts like you run a business. And I think there's areas that we can save money. There's areas where I'd like to see some cost savings implemented, and I will express those ideas to my colleagues on the bench. Tip staffs, I believe, in my personal opinion, tip staffs are not needed at all. What's needed is a secretary's support staff. I'm finding things out that, you know, I've been in the courthouse a long time, but you find things out when you're there that I didn't know. At this position, the position I'm in, a judge gets one secretary. When that secretary goes on vacation, who answers the phone? Who does the work? You know, tip staffs were historically, you know, people that would go into the courtroom, would assist the juries. We need someone to do that, but we also need someone in the office to answer the phone, to do work. Looking at the judges now, they're overworked. And I think it's appropriate, tip staff / secretary, administrative assistant. I think the judges need more help with the office work as opposed to the courtroom work. So pooling tip staffs, I have no problem with that. I believe some tip staff positions should go to administrative assistants or floating secretaries to help a judge when he has a trial, or to help a judge when a secretary's on vacation. I think that's more needed than tip staffs. Tip staffs are obviously important when you're in a trial situation, but all 10 judges aren't trying cases at the same time. So I think a pool of floating tip staffs is, I'm not opposed to that. I think that's appropriate, but I would like to see the judges get more help administratively in the day-to-day operations of their offices, because they are independent offices that are staffed basically by one secretary. And if your secretary is away, you know, I would assume there would be someone to answer your phone, but I don't think that's the case at this point. So what I would look for in trying to implement is some kind of pool of administrative assistance to help judges that are, you know, busy or behind with a caseload, as opposed to, you know, to a tip staff. The traditional idea of a tip staff was, you know, judge's bodyguard in the old days to protect the judge. We have a security staff at the courthouse. The judge doesn't need a personal bodyguard. I think the judges need more help in their office settings to move files and to move cases.
And you mentioned you do have some ideas that you, if elected, you'd share with others on the bench as far as cost savings. Can you give us just one or two examples?
Well, that's one that we just mentioned. I mean, I think looking at the judges' chambers that I've been in, they're overworked, they're understaffed. Allocate resources in the appropriate setting to put people in an office that's needed. If someone's doing criminal work and there's thousands of criminal cases on the backlog, that person needs an extra hand. So I think you would have a floating pool of help from going from office to office instead of being assigned to one judge that could go into a setting where a judge is basically in a trial and has other cases pending to help that judge. I'm a firm believer on the judicial level that the judges shouldn't float around. The judges should do one thing and one thing. You know, we need 4 judges to do criminal court. It's just the way it is. Criminal court has deadlines that the civil court does not have, and I'm a firm believer in you assign 4 judges to criminal court and let those judges just do criminal court. Obviously, we need 3 or 4 judges to do civil also. And you need a domestic relations court. But put that person in that court, and they stay in that court. Kind of now, because we're shorthanded there, judges are doing double and triple duty. You know, I think once we have a full complement of 10 judges, I think you have to put judges in an area, let them stay in that area, and work in that area. You know, I think specialization on that level is important. I'd like to see judges just doing criminal, you know, just doing civil or just doing domestic as opposed to bouncing from one to another. I think you become more effective, and I believe that the bench and the bar could work together. The bar would know what judge is doing criminal for the foreseeable future, you know, and that would basically, I think, improve relations between the bench and the bar. I'm a businessman. I'm a lawyer, but I'm also a businessman. You know, obviously you look to save money wherever you can. I'm also a taxpayer, so I know exactly what it's like to pay taxes. And I would, you know, if I were lucky enough to be elected, I would do everything in my power to fiscally manage the office in an appropriate manner.
Okay. And another home rule related question. There's obviously a group of people now working on ethics and personnel codes. This reader wants to know if you would support efforts to include the judiciary personnel within those ethics and personnel codes.
Absolutely. I'm a firm believer in you hire the best person, not somebody you know. Any jobs that I have in my office will be advertised. I will review every resume that comes to me, interview the appropriate individuals, and make a decision based upon their qualifications, not who they are. I think that should be done across the board on judicial branch. All jobs should be advertised, and there should be interviews done. If I had my way, every job would be interviewed, published and interviewed to get the best people. It's not fair, and we've had this for years, of people getting jobs just because they know somebody. I think every job should go to a qualified candidate, whether it be in the judiciary, whether it be in the private sector. I come from the private sector and public, so I'm on both sides of it. So, you know, when I have jobs in my office, I publish them, I advertise them, look for the best people I can find. And I think that should happen across the board with the courts.
Okay. We talked to all the candidates, and invariably all of them mentioned their experience, their fairness, their impartiality. Aside from those big 3, what qualities do you think you possess that would make you a particularly good judge? Common sense
and practicality. I think a judge has to be, number one, have common sense. You have to look at a case that's in front of you and make the proper decision based upon the facts and the law. And you can't be swayed by who's sitting in chair A or who's sitting in chair B. You have to look at the facts and the law and use your common sense. That's what I tell all my jurors in my jury trials, that common sense decides every case. You look at the facts, you look at the law, and you take your common sense, your life experiences, and you decide cases. That's what you need. You need common sense. And number two, you need to be practical. You know, I'm not going to change if I put a robe on. You know, some people have changed their mindset after they put a robe on. I'm Mike Vough from day one. You're going to get Mike Vough on the bench if he's there. It's not going to change my persona. It's not going to change who I am. I'm a practical person, I think, and I will continue to be a practical person and do what's right. You know, do what's right for the right reason. Don't change your mindset because you're now your honor. That's not going to change me. I'm going to be the same person I've been for 22 years practicing law. I think you treat everyone who walks in your courtroom with respect. It doesn't matter who they are, and you effectively move your cases. Practically, you know, here's an example. You know, practicality that you don't really think of. If you're in a criminal court situation where you have a big list, you have a big list of criminal cases. Some are prisoners, some are people that are on bail. Well, the prisoners are brought in by the sheriffs. And in my courtroom, they'll be the first cases adjudicated in the morning. For what reason? Well, the sheriffs can take them back to the prison. And they don't have sheriff deputies sitting around waiting for prisoners to get done. That's practicality. You're wasting money by sheriff's deputies sitting there guarding prisoners. Take the prisoners' cases first, get them done, get them back to the prison. The sheriffs can do other duties. That's just something that for 20 years I've seen that in the courtroom. And be on time. I'm going to be on time. If my court says 8:30, I'm going to be there at 8:30. I'm not going to come in at 20 after 9. I think being on time, there's people in that courtroom waiting for me. They shouldn't wait for me. I work for them. I should be waiting for them. You know, you have 20, 30 lawyers sitting in a room waiting for 35 or 40 minutes. And the judge is probably working somewhere else, but scheduling is important, and you have to be there. And I will be on time for all of my court proceedings. There's no reason to keep 20 or 30 lawyers, either public defenders or ADAs, being paid by the taxpayers, sitting around waiting. I will be on time.
Can you tell us the appropriate way that you see the jury should be treated, the people in the jurors?
Again, I have some ideas on jury selection, too. The way we do it now, we bring everybody in and they sit. Sometimes 3 or 4 days, and then go home. They're not picked. I'd like to implement a system where we bring all the jurors in on a Monday, like the federal system where they pick 10 or 12 juries on a Monday, and they give them a date to come back, and they're gone. They go back to their lives. Instead of sitting, you know, for 3 or 4 days doing nothing, they come in Monday, they're picked or not picked, and they go home. And then they come back in a week for jury duty, and they sit immediately on the jury. I'd like to implement that, or try to implement that in Luzerne County. I think it's cost effective instead of paying jurors to sit around doing nothing, and it gets them back to their lives. You know, jurors give up a lot to sit in a jury, to sit for jury duty. They basically give up their job, they give up their family life, and they sit there for a week. I'd like to make that a little bit easier experience for them and get them in and out, you know, get them picked on Monday and back home and come back in a week.
What's the appropriate temperament for, or the approach for a judge to treat the jury when they're in the courtroom?
With the utmost respect. You know, without them, the system doesn't work. You know, I feel the jurors should be made comfortable, jurors should be informed, and we should basically tailor our system for the jurors to leave that courtroom with a pleasant experience. And the next time they get a jury notice, not, oh, I have to go to jury duty, or who can I call to get out of it? They'll say, you know what, last time I was there, it was effective, it was efficient, I was treated properly. You know what, I'm going back. I'm going to do my duty and go back. Instead of people trying to get out of jury duty, you try and give them the aspect of, hey, you know, they treated me right the first time. I'll have a schedule. I won't have to sit there all day and get them in and out, and they'll want to come back and do jury duty again instead of trying to get out of jury duty.
How would you treat a lawyer that you felt was behaving unprofessionally in the courtroom?
I'm not a firm believer in a public situation of discipline. What I would do is I would call the lawyer either the sidebar or after the hearing was done into my chambers and admonish them in an appropriate manner. If it's something that is basically violating their canons and their ethics, and if it's appropriate to report them to the proper authorities, I will do that. But I'm not a big believer in publicly censuring an attorney for a minor faux pas in front of other lawyers. I would bring them to the side and basically tell them that I thought your actions weren't appropriate.
What's been your greatest accomplishment in your legal career, if you had to pick one thing?
In my legal career? That's a good question. I would say my success in the courtroom, my trial record at the district attorney's office. I've had more homicides than anyone in the county, if you count the DUI homicides, which I count as homicides. They are homicides. 70 and no losses. Probably one more to go in October. We'll see what happens with that one. And that takes help, obviously. You know, I've had a great team at the DA's office and the ability to be involved in a lot of cases. But the ability to get convictions and get satisfaction for victims' families is probably the most rewarding, and I will miss that. I will miss prosecuting. Being able to take a family that's been devastated, lead them through the process, get them the justice they want and desire and deserve, and have them come up to you after the trial or after the guilty plea and shake your hand and say, you know, thank you for being on our case, thank you for, or thank God you were the one that they called. You know, that's very, very satisfying, and that's something that I will miss, and I'm very proud of my trial record in the DA's office.
Have you ever lectured or taught on the law?
I used to teach years ago a gun safety, legal gun safety aspects to a bunch of groups down in Lower Luzerne County, down in LCC. I just haven't had the time. I'd love to teach. I just haven't had the time in the last, you know, with 4 children and a wife and a practice in the DA's office. I just haven't had the time. Maybe next year, if things work my way, I'd love to get into a teaching situation down the road. But I just haven't had the time to do that until up to now.
Have you received honors prizes, awards, or recognition relevant to the law?
I don't think I have. I mean, I haven't submitted myself for any honors or awards. I look at when someone comes up to you and say you did a good job for me in my case, or they refer a client to me. You know, when an old client calls me and says, you know, this is my friend, he was hurt in an accident, I want you to represent him. I think that's the best honor and award you could ever have. Or a victim's family saying thank you for your work. That to me is more than something you hang on your wall, more than an award from someone. That to me is the award that I want to get, and that's the award I look for.
Has any of your legal work ever been cited in a legal a law review, a journal? Have you ever written anything yourself?
I haven't. Just no, you know, working lawyers, to be honest with you, working lawyers that have the practice that I have and what I've been doing for the last 20 years, it's very difficult to find time to do that. I made a commitment to my children early in their lives that I was going to be at their events. And to be at their events and to do what I do practice-wise and DA-wise, something had to be cut. And I looked at, you know, I want to be at my sons' or daughters' sporting events or at their school events. To be there and do what I do elsewhere, something has to take a back seat in writing and being published. You know, hopefully in the next couple of years I'll be published a lot. But at this point, I just didn't have the time to do something like that.
Could you describe a case in which you've been involved that you consider one of your most significant?
Well, yeah, obviously the glass bar trials brought a lot of press to, I think, a big problem in our area, which is the transient drug dealer problem. The 2 murders at the glass bar. Obviously, the individual that went into the hair salon in Plains with the hammer and assaulted 3 elderly women at their hair salon was a case that had a lot of notoriety, but just for the savage brutality of the crime. The Bullock homicide, where we got into the issues regarding the unborn child and whether the fetus. There was an issue regarding the viability of the fetus. The mother was pregnant when she was killed, and the viability of the fetus. That obviously case went up on appeal and came back. All the DUI homicide cases, they're all tragedies. It's invariably an innocent person going to work or coming home from work, and out of the blue, their lives are ended, and their families are just shocked by what happens, and trying to get fair sentences in those cases. We've been able to get the mandatory sentence increased in Pennsylvania over the last 10 years, and that has brought some relief to families. You know, I always get, you know, well, they murdered my, you know, I say it wasn't an intentional act. Well, they're dead, you know, and they're dead for no reason of their own. And when you tell them, you know, the statutory is 3 to 6 years, they look at you like, you know, how come it's so small? But we've been able, thankfully, to get, you know, convictions on all of those cases that have led to some people actually being satisfied with the sentences. Other people are never satisfied with the sentences, but if you tell them up front and be honest with them, they get to the point where, you know, they know you've done your job and you've done your job to the best of your ability, and the law says this, you have to go by the law. So, you know, I know there's a couple groups out there trying to increase that minimum sentence, and I'm going to wholeheartedly support them when they ask me for support.
What do you think it should be?
I think it should be 5 to 10 years. I just think it's not enough. You know, a lot of counties don't even prosecute those cases. They look at a manslaughter DUI combination. I can honestly say our office from day one, I've been doing them exclusively for like 10 or 12 years now. Exclusively, we've been doing 3 to 6. We don't take less. We don't charge less. We go for 3 to 6. But I think, obviously, for second or third offenders, it should be more. But I'm looking at a 5 to 10. I think would be an appropriate sentence on that. Based on the severity of the crime, the alcohol reading, I think there should be some kind of grading based upon what their alcohol reading is. Obviously, someone with a higher reading is more irresponsible than someone with a lower reading. I think there should be some kind of graded sentencing based upon the alcohol reading and exactly their behavior. You know, what they did. You know, how egregious was their driving? How egregious was their drinking? I mean, I think that all should be factored in to an appropriate sentence. You can't blanket cases. I've been a prosecutor for 20 years, and one of the things I'm very proud of is we had a case a couple years ago in Edwardsville where an elderly man was beaten, left in his house to die, tied up, beaten, robbed, and died in his house eventually 2 days later. There were 2 young girls that were present with their father / uncle, and the mother basically set the crime up. The one girl participated in the beating. She was 16 years old. She participated in the beating. We tried her as an adult. The other girl was just along for the ride. She was 16 years old. She was there. Technically, you know, we could easily have charged her as an adult. But you make decisions. You make choices. And these are choices a judge will make. We looked at the case, and she had no prior juvenile record, never been in trouble before, was sent there by her aunt, led by her uncle. She was 16 years old. She didn't participate in the beating, she just stood there. Didn't stop it, but didn't participate. We decided that she was a life that we could maybe change and turn around. So I decided to prosecute her as a juvenile. She was sentenced until she was 21, placed in a facility, and about a year into it, I got a call from her counselor saying, this girl's doing fabulous. She's one of the best kids we ever had in the facility. She's tutoring other kids. She got her GED, taking college courses. They were allowing her to leave to go to work. And she was able to get out of the facility at 20, a year early. And she's in college now, and she's a productive member of society. That's a decision that judges will make. You know, as prosecutors, we make those decisions also, and that's something that you know, that's experience. That's what you look at when you look at a case individually. You look at each case individually. You can't look at a blanket and say, oh, that case has to be that sentence. I think you look at each individual person, and that was a case that we instead of putting that girl in an adult prison for 10 to 20 years or so, that amount, she was able to go to school, clean herself up, get out of that environment she was in, and now she's a productive member of society. So that's why I look at each case individually, and you can't give a blanket that the sentence should be. You know, you have to look at each case, the person, the case, the facts, and see exactly what the case needs. Does it need rehabilitation? Does it need punishment?
I want to ask you a bunch of questions in a row that kind of get more toward your experience, and I'm asking these of all the candidates. But if you could describe, when you're not dealing with natural disasters and you're not campaigning, how many hours per week normally would you put into your law practice?
If you include the DA's office in my law practice, I'm at work every day at 7 o'clock. I'm normally home by 7 o'clock. Saturdays, you know, 6 hours, maybe 5 hours on a Saturday, not every Saturday. So I'm looking at, you know, you're looking at, but you take it home with you too. It's not like you leave your office and you don't stop thinking. You know, the next day, if you're in a trial, it's a 20, you know, I sleep 4 or 5 hours a day, so it's a 20-hour venture if you're in a trial. So on an average week, I'm there 70 hours normally working, and that's every week. I take 1 week a year off. So.
Could you give us a percentage of, do you have civil cases and criminal cases?
Yes.
Could you give us like 80-20 or 90?
My work is probably 65-35 civil as to criminal. Obviously, no criminal defense. I've never defended a criminal in my career. I've prosecuted for the last 20 years. Civil practice is divided into obviously domestic relations. I do domestic work. I do estate work. I do personal injury. I do workers' comp, Social Security, business. So basically, my range is very broad, and I have experience in pretty much every aspect of the law, both criminal and civil.
Okay. I'm going to ask you questions, and these pertain to the last 5 years. If you could tell us in the last 5 years the number of civil jury trials that you've tried to verdict.
10.
And civil bench trials?
Probably about 10.
Number of civil cases settled?
In the last 5 years?
Yeah.
Wow. $200
Number of criminal jury trials you've tried to verdict?
in the last 5 years? $30.
And criminal bench trials in the last 5 years?
Not many bench trials. Probably 10 maybe in the last 5 years.
Number of cases presented to a U.S. bankruptcy judge?
My firm does bankruptcy. I do not do bankruptcy.
Number of cases presented before a workers' compensation judge?
$70.
And any uninsured motorist cases that you've tried in the last 5 years?
Most of them settle. 50 or 60.
And we're asking these questions of all the candidates. Is there anything that you would want us to know about your experience that you think helps us, that better reflects your experience? And obviously, some people's numbers are higher or lower depending on what area they concentrate in. But
Yeah, if you look at my numbers, you have numbers in every area except the bankruptcy. I do a little bit of everything in my private practice. You know, I have a broad-based experience, and you know, some people do domestic only. You know, some people do personal injury only. I have a general practice. I've had it for 22 years, so I do a little bit of everything. And that's something I think I can go anywhere on the bench. They can send me to domestics, and I know what to do in domestics. They can send me to civil. I can do civil. Send me to criminal. I can obviously do criminal. So I think it's a broad-based experience based upon my practice and my background.
okay. And a number of questions here that we also pose to each of the candidates, so don't get offended.
It's hard to offend me.
Okay. Have you ever withdrawn from a case because you disagreed with a client?
Sure. You have to have a relationship with your client. Number one, if your client disagrees with you on how the case should be tried, or how the facts of the case, that lawyers should not be involved in that case. So there's been times where clients and I have had disagreements about trial strategy, about whether the case should be tried, should it be settled, and the client gets upset when you tell them what you think. And sure, I've withdrawn from cases when clients have not agreed with my advice, or thought we should do something that I felt was not appropriate. I will clearly withdraw from cases, and I have.
How often does that happen?
Well, luckily,
Is it a yearly occurrence, a monthly occurrence?
no, it's not monthly. I would say maybe 2 or 3 times a year. I've been lucky. I have good clients who respect my opinion and follow my advice. But sometimes you get a client that has unreasonable expectations or thinks you can change the law when you can't. So it becomes time for us to part ways. And there's been some financial issues where clients have refused to pay, and at that point, lawyers get out of cases when the client cannot pay your bill.
Have you ever been sued by a client?
No.
Have you ever been sued?
Have ever been sued? I have been sued. What was I sued for? I was sued by a doctor who, I was involved in a medical malpractice case, that we withdrew the case, and the doctor sued me for bringing the case. It's been dismissed.
Have you ever
My client got better and didn't die, so the case lost value. So he decided he didn't want to proceed with the case, so we withdrew the case. And the doctor was offended that I actually brought a suit against him, and he sued me for what's called abuse of process, which the court dismissed.
Okay, thank you for the explanation. Have you ever been found to have made a false statement, an omission, or been accused of being dishonest, unfair, or unethical?
No.
Has your license to practice law ever been suspended or revoked?
No.
Any questions from the group at this point? I'm going to change gears then, and the next line of questioning has more to do, if you're successful in November and you have the job, just to get a little bit of your mindset. Wondering under what circumstances you think it's appropriate, or you would tend to think that court records should be sealed, or filing should be sealed?
The only time I feel a record should be sealed, if there could be some harm done to the parties by it being made public, either personal harm, or there's an issue that is very sensitive to a certain case, that if the facts of the case came out, it could destroy either someone's career, if it's unsubstantiated, or it's just an allegation. I think it should be sealed, but very rarely. It would have to be extraordinary circumstances.
And same scenario, you're on the bench. What factors are considered in granting and setting bail amounts for defendants? What do you believe is the primary consideration when setting bail?
Well, bail is not a punishment. Bail is to ensure someone's appearance. A lot of people think bail is a punishment. Bail is the purpose of bail is to make sure someone shows up. So obviously, if you have an out-of-state defendant on a criminal matter that has no ties to the community, has no permanent address, that person's bail should be set higher than someone who has a long-standing commitment to the community, has an address, has a job. So bail clearly is an individual case-by-case basis. It's not a punishment. People are entitled to bail. It's a legal right. But you look at each case individually, and the person that is a flight risk, that doesn't have ties to the community, that person's bail obviously should be higher than someone that has ties to the community. So bail basically is, a lot of people think bail is a punishment. It's not. It's a right, and you have to look at each case individually, and are they going to show up or not?
And do you believe residents of Luzerne County have adequate access to the legal system, or do you think there are barriers there?
I don't. I think we have a great legal system. I deal obviously on the criminal side with a lot of people that don't have means, and I'm represented by the Public Defender's Office. Some of the lawyers in the Public Defender's Office are the best lawyers you're going to see. We have a great staff at our Public Defender's Office who do a wonderful job. And they're underworked, overworked, and underpaid too, but they do a great job. And I think even the pro bono legal community we have in our area, the lawyers do a lot of work pro bono to get people representation. And I think anyone that wants representation in this county can easily get representation, good quality representation, if they go to the right places and ask for it. On the Hispanic side, we might need to have a little bit more resources to Hispanic people in the language barrier. We might need to get a couple lawyers that are fluent in Spanish to get involved. That's the one issue I see, that there might be a little bit of barrier there, the language barrier.
Okay. I want to ask you about campaign contributions. You are accepting campaign contributions from attorneys. At least you were in the primary. And
Still am.
Continues to be the case. I don't remember from the spring, I'm sorry, I don't remember. Do you place a limit on the amount of money that you accept?
I don't place a limit, but if someone gave me an exorbitant amount of money, I would return it. And what do I consider exorbitant? You know, an average donation in this campaign has been, you know, $500 to $1,000. Somebody walking in my door wanting to give me $10,000, I would give it back. I'm a firm believer in the people that know what kind of judge I'm going to be are the lawyers that I've practiced with for the last 20 years. And they're the people that know who would be a good judge and who wouldn't be a good judge. And I'm thankful to say a lot of lawyers have supported me. And I'm going to be upfront with lawyers in my courtroom. When anyone comes in my courtroom, I'm going to have full disclosure as to who gave me money and who didn't. And if a lawyer wants me to recuse myself because of it, I will gladly do that. I don't think lawyers giving money to judges was the problem we had in this county. We elected the wrong people. You know, if you're above board with everyone, you tell everyone up front, here's the situation. It's not going to have any effect on me, but if you want me to recuse, I will. I think if you do that, you'll see very little recusals when you're up front with people and tell them exactly what, you know, I'll have full disclosure to anyone that asks the question. And I don't think, you know, I think not taking money from lawyers, it's more of a campaign tactic than it really it matters. If you're up front and you disclose it.
So if elected, I'm wondering what steps you think is appropriate to show your independence from those campaign contributions. What steps do you take to let people know who did contribute? I mean, it's public record. If you look online, you go to Harrisburg.
It'll be public record in my courtroom. If anyone walks in my courtroom, I'm going to have a list at my bench of people that contributed to my campaign. If they're on one side and someone else is on the other side that didn't give to my campaign, I will open court, tell both sides, you know, John Smith gave me $500 a year and a half ago. It's not going to happen
now by most judges, any judges?
I don't think it is, but I think it's appropriate to do. You know, I will tell that other party that you know, John Smith gave me $500 3 years ago. It has no effect on my ability to hear this case. If you want me to recuse myself, I will, and it'll be up to them. That's not a basic grounds for recusal either. People think, oh, if someone gave you money, you have to recuse yourself. It's whether I can be fair and impartial, and there's a legal standard there. But I will, you know, be above board and tell everyone, you know. I know Judge Cosgrove was sending letters to, when he first took the bench, I had a case with Judge Cosgrove where he sent a letter to the other side saying that, you know, he knew me for 20 years and it would not have any bearing on his decision making in the case, because the other lawyer was from Philadelphia. And he sent a letter to the other lawyer saying that, and the lawyer had no problem with Judge Cosgrove hearing the case. That's a personal, you know, experience with Judge Cosgrove.
With all the candidates out there, we hear things about them, you know, during the course of normal conversation out in the community. We hear things, and everything I've heard is, you know, great at what he does. Some people have said that you have a temper, or can have a temper. Do you know why a couple of people might feel that way, if there's any?
Sometimes in a courtroom, I'll get animated. It's my job. Sometimes you need to show a little bit of a temper in a courtroom, in a jury setting. It's done for effect. It's done to show the jury that I'm not happy with something that just happened. In my personal life, I don't think anyone would say I have a temper. I'm probably one of the most easygoing guys you would see. But in a courtroom, and on occasion, you know, I can remember a couple times in a courtroom where I got blindsided by a defense lawyer on an issue that I wasn't really thrilled about, and I might have shown some temper there. But in my personal life, I don't think you'll see anybody say I have a temper. There's a reason for that at that time. You know, a witness was supposed to come that didn't come and delays the trial and has a jury sitting there for 3 hours for no reason. That will make me annoyed. You might see some temper in a courtroom.
Any other questions from the group? Anything that we didn't ask about that you particularly want to mention? Any great answer that you had to a question that we didn't ask? Anything you want to answer?
No, I think you asked a lot of very pointed and candid questions. I think I've answered them appropriately. You know, obviously, my campaign is the same as it was in the spring, on my record, on my experience, and my qualifications. I just like everyone to look at the qualifications of the candidates. They have 7 good choices here. Look at the qualifications and pick the candidate that could best do the job. Someone that's been in a courtroom, someone that's picked juries, someone that, that's the job of a judge. People don't realize the job of a judge is to adjudicate cases, to get into a courtroom, to decide cases, or to be the neutral referee of a jury trial. And the best experience to do that is someone that's been in a courtroom, that's picked juries, and someone that's spent their career in a courtroom. And I think the general public looked at that in the spring, and I hope they would continue to look at that in the fall, and pick 6 people that are qualified that have been in a courtroom, and that's the best experience to be a trial judge, is to be a trial attorney.
Thank you so much for being here.